evening and welcome to the July 19th, 2022 Planning Board meeting. Nancy, please take attendance.
Yes. Member, what I did with my sheet. Commissioner.
Say it again, you broke up.
Commissioner Narenberg. Can you hear me? Yes.
Ray, unmute yourself. Unmute.
Unmute, Ray.
He's here?
Yeah, he's here. Yeah.
Okay. Commissioner Barra?
Here.
Commissioner Carpenter?
Here.
Commissioner Wolfson?
Present.
Commissioner Michelle?
Present.
And Chairman Leo.
Present.
I'm here. My audio got working.
Okay, great. This evening we have the approval of the meeting minutes, 30 Elm Street, 25 Main Street, 125 Columbus, and 31-33 Main Street. At this point, can we have 30 Elm Street up, please?
Got it. Oh,
No, wait, Ray, you gotta wait.
okay. What's that? You want me?
No, not yet.
Okay.
I can't hear you, Len.
Can't hear you, Len.
What's up? Okay.
You're on mute.
You're on mute. Something's wrong with your mic.
You're still on mute, Lenny.
Yeah, I think something's wrong with his mic.
It says it's muted.
Caroline, can you unmute him?
Hey, can you guys hear me? Hello, everybody.
Yeah, we can hear you.
Yeah.
I guess it's working now. It was something with his microphone,
Something
Antonio.
with my microphone not connecting with my speaker,
There
whatever
we
reason
go.
they weren't
I can
talking.
hear you now, Lenny. It's all
Okay.
good.
Good evening, Mr. Chairman and members of the board. I'm Len Brandis, representing 30 Elm Street for Pyramid Squash. After discussions from our last work session, the recommendation to be open till 10 o'clock for the parties and the parking lot as well till 10 o'clock and close at that time is certainly acceptable to my client and who would wish to proceed at that time limit.
Okay, does anyone from the board have any additional questions for this applicant?
I don't know.
Sorry?
Not
Oh, you
here.
don't?
No, I think we
All right.
covered everything.
Okay. So at this point, I make a motion to open the public hearing. Can I have a second, please?
Second.
Second.
All in favor? Aye.
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 Is anyone here this evening to speak on this application? 30 Elm Street? Since I see no one here to speak on this application, I make a motion to close the public hearing. Can I have a second,
Don't
please?
move.
All in favor? Aye.
Aye.
Ray, can you read your resolution, please?
Got it. Planning Board Resolution Decision. Applicant owner GA Lord LLC, DBA Pyramid Squash Club. Location of project 30 Elm Street, Tuckahoe, Section 32, Block 6, Lot 4. Description of project. Amend site plan to include a party room for small gatherings and events and parties. Seeker resolution. Pursuant to the regulations of seeker, this board finds that the action taken herein is an unlisted action subject to the requirements of seeker and implementing regulations. The board is in possession of all information reasonably necessary to make the determination as to the environmental significance of the proposed site plan application. That the action taken herein shall not have a significant adverse impact on the environment, and it is declared that a negative declaration is hereby adopted with this regard to this action.
Can I have a second, please?
Second.
Nancy, please take, no, you can't second, Ray. Can I have a second, please?
Second.
Nancy, please take a roll.
I'm sorry, I didn't see who seconded that.
It was Mr. Wilson. Commissioner
Wilson,
Wilson.
okay. Okay, and roll call is Commissioner Narenberg,
Or
Commissioner Barra,
Or
Commissioner Carpenter,
I'm sorry, I'm just gonna abstain because I haven't been for the two meetings, so I don't feel kind of comfortable voting because I'm not sure what's going on as much.
Very good. Commissioner Michelle?
In favor.
No, I don't think Commissioner Michelle can vote. She's ad hoc. I think all the members are here, right?
Oh, sorry. Yes. So that's too many. Okay.
Yeah.
And Chairman Leo?
In favor.
Okay, thank you.
Ray, continue, please.
Yes, sir. The following is the resolution decision of the planning board of the Village of Tuckahoe, New York. Applicant is seeking to amend their site plan to include a party room for small gatherings, events, and parties. Due to the pandemic, this board understands the need for businesses to evolve to include services a bit outside the scope of their normal function. The applicant is a squash club seeking to add a party room at its premises. We note that the applicant has had several parties in the past and has received a few complaints due to the noise. We have kept the public hearing open now several months, and we note that there has been no opposition from the public to this on this application. We find, based on the work sessions and the presentation to the public at the public hearings, that the applicant has met its burden to 7-1 of Village of Tuckahoe zoning code, and therefore the application is approved with the following conditions. 1, parties shall be limited to no more than 47 people. 2, parties shall end promptly at 10 p.m. 3, parties shall be limited to participants of the applicant. If there are 3 valid complaints as determined by the building inspector in any 12-month period, then the applicant must appear before this board to determine if this amended use shall be revoked. Approval as per drawings SY 001 A103 dated April 26, 2022. Every representation of the applicant made in its application and presentation will be a condition of this approval. Any deviation from the representations shall be cause for the revocation of said approval. Meeting date, July 19, 2022.
Thank you, Ray. Can I have a second, please?
Second.
Nancy, please take roll.
Chairman Leo, should I call Commissioner Michelle if Commissioner
No.
Carpenter is abstaining?
No, she abstained from the previous application. Commissioner Michelle can only vote if one of the commissioners is absent.
All right, so
She's
that's
ad
it.
hoc member.
Okay. Commissioner Narenberg,
Or
Commissioner Barra,
4.
Commissioner Carpenter. Abstaining.
Yes, I'm abstaining.
Okay. Commissioner Wolfson
4.
and Chairman Leo.
In favor. All right.
Thank you very much. I appreciate all your help on this.
Okay, great.
take care, Len.
Okay, at this point, can we continue with 25 Main Street? I know you're the architect for that as well.
Hi, everybody. I'm Jessica Loser. I'll be presenting with Len tonight on the lot line adjustment application for 25 Main Street.
Okay.
And if I may share my screen.
By all means.
Great.
Carolina,
Thank
can you let her?
Yes, it's all good.
Thank you.
Thank you. Yep, I'm all set. I'm going to make this a little bit bigger so that it is viewable from everyone on the screen tonight. Last time we presented before the board, there was request for additional information to be shown on the survey, as will be recorded to show when the lot line application is approved. If you'll note, there is far more information with respect to lot lines and property ownership to the, we'll call it plan south of the building. There are these lots here in the parking lot that are owned by the Village of Tuckahoe and are now appropriately identified. There are additional access ways on the, we'll call it plan west side of the building. And these lots on the other side of the parking lot that are now fully identified. I'm going to zoom out just so that you can see the full lot. To reiterate, I'm going to make it a little bit smaller just for a moment. But this is the boundary right here in this heavy dark line is the boundary of the proposed new lot line. And before we get into other issues regarding the site plan, I just wanted to know if there are any questions about the proposed new lot line boundaries.
The only question that I have at this time is, with this revised survey site plan submitted to the village?
It hasn't yet been submitted. It was prepared and ready this morning, just in time for this meeting.
Okay, thank you. Anyone from the board have any questions on the lot, the location of the lot?
No.
None here.
Thank you. So I'm going to zoom in now onto the much discussed parking spaces adjacent to, on the outside of the proposed lot line. My understanding is that it's important that we figure out what is allocated to the building and what is not allocated to the building, just to ensure that this building complies with all the required available required to be made available parking spaces for its tenants and patrons. I'm going to show you two diagrams. The first one is just sort of zooming in onto this survey to show the spaces that we have demarked here on the right side of the building, and then here on the left side, all the way on the other side. There is a lot of history with respect to these parking spaces. Peter Borducci is here tonight to help put together the historical narrative of these parking spaces. It's really a shame that, not a shame in terms of fault, but that the town and the village does not have any historical information about how the site was approved the 2 times before that it was approved. And our own files are missing. We have notes and we have references to conversations, but we don't have signed or written agreements. What we have been able to find, and this will also be, Chair, this will also be submitted with our survey. We have a stamped site plan that shows, and I'm going to zoom in and just confirm for me that the picture changed. Hang on one second. I'm sorry?
You rotated the image.
Yep, I got it. I got it. Give me a second. There we go. Trying to fit it in and make sure that it can be seen. Seems like a tricky task.
In your upper bar, does that square, just click the square.
No, but then it goes in, I think, where it gets, the essential information gets blocked by everyone's screenshots or profile faces. I think now it can be seen, but what I'm drawing to your attention is this is a approved site plan signed by Bill Williams showing these parking spaces here, 1 through 13 on the right side of the building, and 14 and 15 with the garbage.
Yeah, I don't think anyone is questioning the validity of those parking spaces. I think the only question truly is, in your site plan, it indicated that there is a parking easement, and we were trying to figure out where this parking easement came from. And so no one is questioning that those parking spaces are not there. So
great. Up until this point, I thought that there was a question about whether the question parking spaces were appropriately sort of counted towards the building's parking requirement.
Okay, so since we last spoke, we were able to find the resolution for this application. And in this resolution, it indicated that these 12 or 13, whatever they were at the time, parking spaces were to be metered so that they can be used for this facility. So that for some reason never occurred. And unbeknownst to anyone why it didn't occur, I'm not really quite sure. So those parking spaces do exist there, number one. Number two, they were to be short-term meter parking spaces. And I think we as a community had a concern on your site plan where and I think it still shows the parking easement. And I guess what Gary, our attorney, was indicating, okay, where is that easement registered? And I'm hoping that perhaps you have some information on where that's been, because if you look at between parking space 10 and 6, you know, it says the word parking easement from the ramp to the edge of the end of the parking lot. So we're trying to
Yeah.
figure out so that we can put this to bed once and for all. We know exactly where what belongs to who, what's supposed to be there, and so that we don't have this issue 10 years from now.
Ever.
when,
We
you know,
should
something else
etch it in
changes.
stone like a Hollywood square at the site. My understanding is that the parking easement is as noted on the survey, and forgive me, I keep pointing to my screen as if we're all in the same room. It's an old habit.
Use your
The parking
cursor.
easement, as noted, is the former walkway to the building, and that had initially been a walkway easement access. Otherwise, the building would be completely landlocked. When Peter redid the entire entrance and built that wall, he moved, I can do this with my cursor, he moved the walkway from this area to this area. But that this area here remains an access easement to the building. Now, you're right, it's not, we have not been able to bring forward any documentation that codifies this easement. And short of going round robin again, I would like to propose that with the eventual sale from Metro North, that we would properly record an easement so that it's
Hold on.
recorded against the property.
So okay, so I'm a little confused though. So if we're saying that the property line is a dark outline, right? Your new property is your dark outline.
Correct.
Okay. So, and if that quote unquote easement section was your property, why isn't it registered as your property?
No, it was an access easement. Peter and Len,
We have
correct
a
me if I'm
record
wrong,
of
it's
that
an
access
access
easement?
easement from the village for access to the building.
Is that recorded anywhere?
No.
Okay, so first, I think first things first, we got to take that word parking easement off that drawing, because unless we have a document that states that there's an easement there, I'm not sure that's accurate, correct?
I don't know. I mean, it's really hard to say in the absence of a document. I don't disagree, but I don't know that we want to
Right.
relinquish that right here in this meeting, as opposed to finding a way to rectify it through a proper recording of an easement.
So Jessica, I have your title report. There's an easement, library 6288, page 478. That's kind of the only easement I see on here. Do you know what?
Right, is that the
easement
water?
Is? Oh, that's a water easement? Okay. Thanks. That's
Like
all I need to know.
1963, I think. Yeah.
Okay, it wasn't attached, but that's, okay, so now I know what it is.
So Peter, I know you want to speak, but you have to unmute yourself.
Can't hear you, Peter.
Carolina, can you help them?
Got it.
There we go.
All right,
Work
can you
now.
hear me?
Okay.
Yeah. So, I just want to, Jessica, you did a great job describing the access to the building. But just for clarity, I would like to tell the board what the original plan was with the access to the building. The access to the building, well, let me go back a little bit. The access to everything by vehicle access, trucks and cars, utilities, and the access for the pedestrians was something that I had to have from Metro North. And if I didn't have it, Metro North knew that I could not purchase the building. At the time, I purchased a 260-year lease and waiting for the deed to convey to me, which is now. So none of the easements were existing before. So Metro North
must have negotiated, talked to. I was present at times I wasn't with the village. And here they are, the three easements. The truck easements, cars and vehicles, the utility going to the building. I have to note that the utilities going to the building were going to Main Street back in the days that they used the building, and then it was mothballed 30, 40 years ago. So, but they were no longer viable. So we got a new easement to go to Lake Avenue. And the pedestrian easement was directly in front of the building entrance, which was pretty nice. I mean, we had a rendering from Peter Gator at the time. It was, right in front of the doors, was really nice. And parallel with that, we were trying to find out how many parking space we need. And we determined with the help of the building department that we needed 21 spaces. So I told my attorney that we got to figure out a way to get these 21 spaces to the building. Now, the easement was already there, proposed and agreed to my recollection and to my daughter's recollection, by the village and Metro North. The spaces were still being discussed. So John Cavallaro was waiting for an okay for Metro North due to some covenant that Metro North had with the village with this particular parking lot to change what was called, the two names were, there were two types of parking spaces in that parking lot. One type was commuter and one type was metered. There was only about 20 meters in front of the building and some meters at the building, and they were deemed meters, an hour, 2 hours, 3 hours. All the rest, up and lower parking lot, was commuter parking. So the village needed to agree or have an agreement with Metro North that it would have been possible to change 21 additional space, which by that time we found out that we need at least 21, from commuter parking to the only other name available at the time that they care about at Metro North was metered parking. And nothing to do that to be metered forever. There was another conversation going on as to what the parking was for, which was for the building, not necessarily metered, but those were the two specifics recognition of parking in that particular parking lot. So John Cavallaro received a letter, and it's mentioned in that declaration from Metro North that it's okay to take away 21 spaces from our commuters. Yeah, it was great news. The village did a lot of homework to accomplish that. They had to prove to Metro North that in the village of Tuckahoe, they had at least, I may be wrong with the number, the village had at least 400 and somewhat commuter parking, which was their minimum number, whatever the number was, I may be wrong, could be 405, 410, don't know. But whatever number that was, the village was able to tell Metro North, we have that between Oak Avenue here and Crestwood. And that's what triggered their decision to say, it's okay to let go of 21 commuter spaces. Then along comes Metro North suggesting to me, would you consider buying this piece of sliver of land from us and the one going north, but this in particular, and move your walkway over? And I remember roughly about 18 feet. And I said, well, I don't know if I consider, but I did consider it. And I got prices for the wall, and it was ridiculous amount of money. Instead of building the walkway on the proposed sliver of easement, which would have been directly in front of the doors where the parking numbers are right now that you guys are looking at. So I agreed to that, to some great relief of Metro North, that now I was only going to be looking for, at the time we had 13 here, 2 on the top,
which made it 15. So the additional spaces that were required that I would have to buy from the village was 6. Turned out to be there was more than that because handicap space was introduced, which took 2 spaces instead of 1. So now we have 12 here and 2 on the top, which is 14. So the end result, I needed 7 more. But everybody was happy that I did that I decided to move to walkway to a great expense versus building a walkway on the ground, which would have been probably, don't remember the numbers, my daughter knows more, but like 200,000 versus 500 and change. By the way, I'm happy with the result. It looks just as good that if it was directly in front of the doors. But that is the history of what happened to the walkway, and the driving force behind me agreeing to buy that piece of land, which wasn't that much money, but the builder was a lot, was to preserve what was going to be a pedestrian walk into what I would need to be parking. And that was the understanding behind this whole event. Why we can't find a registry somewhere at the county, I don't know. I really don't know. My attorney passed away. He would probably have an answer about that. I found out recently that the title company is no longer. They're supposedly had to record all these easements. So I'm at a loss on that. So when Jessica suggested what she just suggested, I thought it was a great idea. Knowing that this always existed from day one to now, every document showed that called pedestrian easement. By the way, I changed it to what it really should be. That's the only thing I attempt to change to parking easement. And Bill and I had a conversation on this, and it really didn't matter. It didn't matter legally or otherwise, so I changed it. But we could easily put it back to what it was named, pedestrian easement. So I hope I clarify some of the history on that. That's really all I'm trying to do.
Yeah, Mr. Verducci, I'm looking at the resolution from November 10th, 2008. I have a copy of it, and I could read it to you. And actually, you state that, actually, your daughter states that Mr. Verducci stated that there was an agreement between the Village of Tuckahoe and Metro North regarding the parking spaces. She also noted that a letter has been submitted to the Historical Society regarding the status of the building. So, Bill, has anything turned up in the files that shows this letter?
I have found John Cavallero's files, and if Jessica would like to come down along with Gary, we could go through them and I could show you the paperwork that I have from Mayor Eklund to John Cavallero outlining how the 21 spaces are to be done. And there's
right. So
he mentioned of a easement other than an agreement that John proposed be put on the agenda for compensation for the parking. So if they want to come down and go through all those papers, save everybody a lot of time, we can do that.
So Jessica, if you could schedule a time with Gary. I think he said his computer froze, so he is currently not on. Hopefully he'll join soon. But it makes sense to go through our files and see what you can find. Hopefully that to kind of resolve this issue. But the resolution also says, and it states the following: John Cavallero, village attorney, noted that the village has received a no objection letter from Metro North regarding the conversion of 21 long-term metered parking spaces to short-term metered spaces. The spaces have not been determined as of yet and will be by the police department. The 21 spaces are not reserved for the project, just to accommodate any potential patrons. The spaces will be short-term, 2 to 4 hours for use by non-commuters. So, I mean, that's the language. And then, of course, there's a resolution that goes along with that. But that's the language in the meeting minutes of November 10th, 2008.
So I have a question, and I hope that I'm not overreaching or being too greedy sounding. But just to sort of highlight your question earlier, that the parking spaces are outside the proposed lot line. I'm not saying they're not important, and I don't want to speak on behalf of Peter, but I'm happy to come down and go through the files. But I would like to separate out that information seeking session from the approval of the new lot line. The just as an aside, the MTA is they're in a very weird position. I think most state and local governments are experiencing an employee shortage. There are like 1 or 2 attorneys where there used to be teams of attorneys, and our timeline for closing is going to be difficult. And so we'd like to at least get through this part of the process so that we can get on to the next. If we're committed to continuing to find and rectifying, and if we can't find, rectifying in a manner that's appropriate and approved by the board, can we separate the issue of determining where the easement generates from with the approval of the lot line?
Gary, do you have an opinion on this?
Yeah, I guess, technically he's leasing this anyway for a long-term lease. He's switching that lease to a fee now, where he's now going to own this. I don't think that the approval of switching it from a 248-year lease or whatever he has to a fee ownership really impacts the issue of parking. The building's there, the parking's there. I can call John to see what he remembers about those parking spaces, but I think it's pretty clear with those parking spaces that they're supposed to be metered for the patrons of the building. But it would have been nice to, I think I don't want to get in a situation where if they get their approval that we lose control of this or lose sight of this again. Because this
No,
has been
I'm
going,
committed. I really am. I mean, I know that I don't have a long history with the board, but I'm committed to helping resolve this issue. It would just be a shame to lose our window of opportunity at MTA because there's 1 or 2 staff attorneys while we're on this seeking mission.
and I could vouch for Jessica. She's been wonderful. She's very responsive to any time I call. She's been a pleasure to work with thus far.
Thank you, Gary. Same.
You're welcome.
Gary, I don't want to interrupt, but I have a document that's in John's file that the MTA agreed that we could remove the short-term meters and that Peter was to work out an agreement with the village for compensation for the parking. So the short-term meters were agreed to be removed by the MTA, and I have that document.
Yeah, I think that's the document that they were referring to that says, hey, you can take these 21 spaces, because Metro North wanted long-term commuter spots there because that's their, that's the train station. So they agreed to release a portion. And Bill, I think I've seen that with you. That's they were saying that they can make those spots metered spots, short-term metered spots for the patrons. Is that the one you're
what's the
referring
date of
to?
that document, Bill? What's the date of that document?
I don't remember the date, but it's late in 2008 or 2009 that said that Metro North agreed to remove the short-term meters and for Peter to work out a deal with the village for the parking spaces. So they agreed that the meters could be reduced from short-term to no meters for the building.
Gotcha. Peter, do you recall that, or do you remember?
Yes, I do, and I wish I had Rocco's files with minutes. Unfortunately, at the time, Gary, those emails were not as
Yeah.
continuous as they are today. So Lauren was able to find an email, but then nothing after that. I even called Rocco's wife to see if there's whatever leftover boxes are there. But if I could tell you what I recall, I was at a meeting in the village after what Bill just mentioned. The Metro North really didn't care about meters or no meters. You work out a deal with Peter. And the discussion was very, very to the details that, yes, okay, Peter, so you have 13 spaces. And then and I don't remember the history of where the garbage containment area and the other 2, but it was I would have to say it was along the same discussion, but they're really sticking out a foot or two off over the easement line. That was the words that the ex-mayor used. John Cavallaro was there, Rocco Salerno was there, Lauren was there, and I was there. So somehow they came up with a formula that instead of 7 spaces, I thought it was always going to be 6, but turned out to be 7 because the handicap took 2 spaces. I would have to pay for 10 spaces instead of 7. And that went on for years. I agreed to it. I walked away. I didn't want any problems as far as reinvent the wheel. At the time, I was eager to get it over with. But that's what I recall after what Bill just said. Yes, Metro North didn't care whether those spaces were metered or not. They were the only thing that they were concerned about is that I would get some spaces for the building as they promised me to help me with. So Bill, do you remember anything like that, like I just described to you?
Peter, I have the documents that go back and forth between John, Metro North, Mayor Eklund that outline the details of those parking spaces and the compensation for them, and the fact that Metro North was okay with the meters being removed and working out the compensation with the village.
Yeah.
So that's why I suggest Gary get down, Jessica come down. I got the folder in my office. I got the documents readily available and they can look through them. And I suggested Jessica and you also sit down with David Burke and get their feelings on how to iron the rest of this stuff out so you can settle it for once and for all.
Yeah, and I think Peter said something that was fairly interesting. He's, because I saw a survey where there was a pedestrian easement that looked like it went through a portion of the parking spaces. So that parking easement's really throwing me off because I don't think there's a parking easement there. But if you go back and look at the survey with the pedestrian easement, I think that's going to tell us a lot more. I don't know who put the parking easement in there. That was probably not appropriate to put in there.
Right, Gary, I think what you're connecting is the evolution of the walkway easement, which became a parking easement once the ramp was constructed.
Yeah, but Gary's right though, Jessica. It was never called parking easement.
Right.
I named
But
it that.
through your conversations with Bill, it sort of became an
Yeah,
unofficial.
it got confused
parking
matters
easement.
even more.
And that throws us off when it's not that. So if we can see, and was that pedestrian easement?
I believe I have that available. If you can let me share for a minute.
Oh, yeah, I'll stop. Go ahead, Len. All yours.
Okay. Let's see if I can find that one. Just have a bunch of these here, so hold on a second.
Hey, Carolina, there's a message that someone needs to be let in on Zoom.
There's one there.
Yeah, there's
It's
no
been there
one
for a
showing
while.
up right now.
Sorry?
It might have been me.
We don't have any participants in the waiting room.
Okay.
Do you have me on my screen?
No.
All right, let me get back in and we'll share that. Hold on.
We had Gary, right, Gary, in the waiting room? But all good. He was the only one. Nobody else showed up.
How about that?
You're sharing.
It started, yeah.
All right. So we're talking about the area that this was considered. This was the original pedestrian easement over here. The original wall was over here. There was a temporary stair because of construction that was going on with the lot, and there was a temporary stair that people were using from Main Street, going through here, and then going down to the area to go down to the parking lot. As far as I understood, because I went back to put in the final pedestrian easement over here, the walkway, that we had shifted that walkway all the way back to here, moving this wall a little bit more than 6 feet, between 6 and 8 feet, depending where we were over here. So our walkway is back over here, and the idea was that we would get the space from here, from our new walkway, back to here for the parking.
But
The
you
original
can't,
parking area
if there's
did
an
not-
easement, you can't readjust the lines. You know, we need to see what that was.
Right, this
You
pedestrian
can't hold
easement.
something different.
Documents that were approved in the town, that were stamped in the town itself and approved. So this is how it was set up originally.
So is there a pedestrian easement out there from way back when?
Easement, as far as I can tell, we can see if there's any documents on this.
Because I've seen the old documents refer to something as a pedestrian easement, and it made sense.
Right.
But we need to see the easement to see where it is. Like, we just can't move the lines and say, now this is a parking easement. Oh, and by the way, we shifted it.
Correct.
Kind of not the way easements work.
Yeah. So,
Understood.
Len, can you move that to the left? It says go down toward Lake, go down toward Lake Avenue.
Sure.
Move it up a little bit, a little more. Now,
Down.
can you move it, go past Lake Avenue, the word Lake Avenue to the north? See, yeah, there you go. So this is the only thing I was able to find. There's notes here, and I asked him, what does this mean? To everyone I've been asking for years. Easements shown here on have been calculated and added year on October 6, 2004. Easements, all of them. So even the 10-foot, which then became bigger because when I moved onto the new piece of land, the walkway, I gained a couple of feet. I forgot I'm much land. I can't be exact, but this is the only thing I could find anywhere but the easement. Now, if Rocco was still around, I would ask him, what'd you do to me? Did you not have
Yeah.
the title company record this? You know?
And that's a good point, because, you know, it says here, I'm looking at the title report. It says one of the exceptions is the premises appear to be landlocked. An access easement is required through lands now or formerly of the village of Tuckahoe. But your survey here says there's an access easement. And the title company is saying, hey, it doesn't exist. So I don't know why it now appears on a survey showing that there's an access easement. Yes, you need access to the property. It can't be landlocked, and that's kind of give me. But the harder ones, obviously, this pedestrian parking or whatever.
But Gary, these, I believe, I may be wrong, Len, Gary, that these easements were originated in this year, 2003. And it says note number 2, they were placed on here. Somebody must agree with Metro North to allow the 3 easements, the utility, the vehicle easement, and the pedestrian easement at the same time. So I am baffled by the fact that, you know, that there's no, I don't know.
The question is, do we have the title from the title company here, PFC Insurance, which certified this title number of PFC 15672? Which is showing these easements.
We may have it in the file, but the problem is your title company now is not finding it. And now, you know, if it's recorded with the county, it's there. It's going to be there forever. So yeah, I'm not sure. I'm confused with this also. I think Bill made a good suggestion that we set up a date that, you know, once, Bill, you get everything together, have Mayor find everything that's in the file, that we just meet down there and look through this thing and see what's.
I'm happy to be part of that.
Yeah.
Yeah, me too, if you need me, absolutely.
Mm.
But if we could resolve with a note, with an agreement that this has to be determined further, so that I could, they can convey me the document that they are waiting to convey. They meaning Metro North, MTA, not Metro North. The MTA, which is the owner, so that I can move on. That will help me tremendously. I don't know if I'm asking too much.
We don't have a resolution prepared because I know there's some more documents coming in, but what's the time frame on that, Jessica? Do you know what Metro North is telling you? Did they give you a drop dead date?
No, but it is very difficult to get them because they are stretched so thin.
Gotcha.
I mean, I wouldn't want to misrepresent our conversations with Metro North, but I'm concerned that if we miss our window, we'll be placed on their back burner for a very long time.
Gary, I'm sorry, on my agreement on the purchase of the lease says that on or about 2014, Metro North will be able to convey the deed to Peter Borducci at the time. Well, that never happened. And the reason for that is that I was, just a little fly in the ointment for other problems that Metro North was trying to resolve with their parent companies, including Grand Central. So finally, when they resolved the biggest elephant in the room, they called me, which was a year ago, and say, we're ready. And as you promised, Peter, you have to do the subdivision for us. And that's what I'm doing.
Okay. The other, Frank, I know we spoke to Frank today. He was supposed to be on here. I think he was having trouble getting in, but he's going to be integral in this too, because he was part of this application back, right? And I could reach out to John Cavallaro to see what he remembered, but Frank hopefully has his notes and to see what transpired. Bill, is that correct? Was Frank on this project back then?
I believe so, yes.
Okay.
Yes.
All right. So, I think we're going to need him for a little more than the secret stuff, because we need him to go back and look to see what he can find out with his files, what was supposed to be going on here. But going to Jessica's point, I don't think we can do it tonight, but, we can separate the issues, again, turning a 250-year lease into a fee and doing the subdivision that way, we could probably, but we would still need to work out those parking issues, because
Right.
we have to find out what's happening down there.
And it might be the case that we find documentation with, between now and the next meeting to substantiate everything that we have said. It would just be a shame if we don't find it, and whatever solution that both sides can agree to takes longer than another month, then things are going to start to slip.
Right.
Look, we're going to try to help you as much as we can, but you got to help us as well. So the more information you provide us, the quicker. I mean, I don't want to get it resolved as quickly as possible for you.
I joked with Peter earlier because he said his attorney died, his title company closed up shop. I said, I don't want to have anything more to do with this application.
You want to get out as quickly as possible. I understand.
I also want to suggest.
Well, no, I might end up, in Kansas.
Yeah, you too, yeah.
I also told Jessica earlier today that, and I want to volunteer for this, Gary, that unfortunately I was granted permission to go down from a certain number to a certain number, and I was only for a year. And then, wishful thinking, we thought this was going to go a lot faster. So another year passed, and I'm not forgetting that I did not renew that, and I didn't get the consideration wasn't extended to me. So if I need to come to the village and straighten something out, Bill hinted a couple of times that there is something to do with that. And
let me talk to
and I
David
fully
Burke
agree.
and let's see what we can work out short term while we try to figure out the long term solution for these other spaces.
Good.
Hey, can you give me a copy of this survey?
Which one?
I'll get you copies.
Of this one here, because I'd like to overlay the new one over top of this one to see how the meets and bounds line up.
Okay.
Bill, you hit the nail on the head. That's exactly where does that 10-foot pedestrian easement or whatever it is, where does that land on the new survey that they're showing us now?
It's this line back up here. That's the line that coincides right there.
Yeah,
Right,
we'll give you.
right behind the wall.
Yeah, Bill overlay it. Bill,
So if you go 10 feet from the wall, that eats into part of the parking spaces,
Correct.
but not the whole parking space. It probably 4 feet of the parking space. Is that?
No, it looks like it's 10 feet.
If I recall, 'cause I did go before the board to create the walkway, the new walkway that is there. And there was a big discussion on this whole thing with the parking, and that we needed approximately between 2 and 4 feet, depending where we were on this area, to create the actual parking going perpendicular to the space. Originally, the parking was horizontal. You only had like 3 spaces over here versus getting 12 spaces by taking a couple more feet from the parking lot itself. And that was a discussion when we built this new section over here. And that's why we put it all the way back over here. We built that wall so we could put it back as far as possible, shifting this wall up about 6 feet. This wall went up about 6 feet from where it is now. So the new area is here. I can So I can,
Okay, so Len, please send the drawings to Bill, both drawings.
I'm going
And then
to,
Jessica, Bill, and
that's the new Cheryl.
Gary, if you guys can schedule a time to go through the files and see what you can find, and hopefully we can resolve this so we can get you out of here and closing your building.
Great.
It'd be great. Thank you, Chair.
All right, guys, thank you. Have a good
Okay,
evening.
thank you, everybody.
Thank
And
you.
Bill,
Have
I'll
a good
get that
night.
paperwork to you.
Good luck.
Thank you.
Thank you.
Thank
All
you.
right.
Thank you, Jessica. Thank you. Glenn.
Thank you, Peter. Thank you, Len.
Take care.
Thank
Yeah,
you.
bye, guys. All right. Mr. Tavalila, how are you, sir?
Can you hear me? Okay.
Yes, I can hear you. How are you?
Good, good. How are you?
Doing well, thank you.
Good, good. Last time we spoke, we had a couple issues left. Happy to report, I had the body shop all cleaned up and he removed 4 or 5 cars from there and cleaned the, the walkway there and got rid of the brush and, so hopefully you got a chance to see that.
I was told that it's better and I get a chance to stop by.
Yeah.
I think Commissioner Wilson said, you said it looked a lot better. I
Yeah.
think Mr. Williams also said it looked a
Sent me
lot
some
better.
pictures and my brother took a look down there and, they got that straightened out.
Okay, but it looks like there's a little bit more that can be done, hopefully.
We'll keep trying.
You're the landowner, so you can.
Well, he did a lot. He did a lot. He had about 7, 8 guys there. They were cleaning up stuff. They junked a bunch of cars, and my brother told me it looked really good. So I don't. A couple of people did tell me, and I didn't get a chance to go down there, but they sent me pictures, and it did look a lot better.
Yeah,
I
it's
can
looking
tell you
better.
that. Yeah.
Have you seen
I
it,
went
Dave?
by as well, looking better.
Have you seen it, Dave?
Yeah, yeah.
Thank you.
Does it need more?
Well,
Be honest.
I am. Look, it's a big improvement, so.
But that's not the question. Does it need more? Be honest.
I think it's,
Yes, the answer is yes. Okay.
it's, okay.
I'm going to say yes to that.
All right. Then, the second issue is I spoke to the town assessor, Michelle Licio, and we found out that the net value of the property increased by, with that addition, moving that line, $87,190 from the old value. And so I know we spoke about being prepared to pay 10% rec fee on that differential on the.
What was the number? What was the numbers?
$87,190.
Okay. My understanding, and again, forgive me, I was told that the new lot value is $326,860.
Here's her notes right here. The assessed value went from, the market value was 543,801 before. And with the addition of that, the other lot, then I guess it changed to 630,991 was the total lot value. So there's a difference of $87,190, which when we discussed everything is in the minutes of the meeting, the rec fee was going to be 10% of the differential increase in property value.
True, Paul. We've never done that. The value of the newly created lot is what we base the rec fee on, not the differential.
Well, that's what's in the minutes, and that's what we spoke about. And I specifically asked you guys, what's this rec fee gonna be about? And everybody there, and you could look back at the minutes that are approved, and it says right here, rec fee 10% of the differential increase in property value.
Never use that word.
Well, look at the minutes from
I don't look
June
at the
21st.
And I know what I've done in the past.
You got to look at the minutes, and then you'll see.
Okay. Okay.
That was from June 21st meeting.
Yeah. All right. We'll check that out.
I mean, I'll be honest with you. I do have an issue with this rec fee because I'll tell you why. And I would have been willing to pay the, like 8,000, 9,000, whatever that would have been on the difference in numbers. But we're not, I mean, these other numbers you're coming out with, they're crazy. And the rec fee, and good for Bill for pointing out that this is part of the zoning board, that this could affect you. But the bottom line is that I've spoken to a few people and they usually don't charge a rec fee on commercial property. They charge a rec fee if it's a residential property. I don't see, if you read this here, this is up to the planning board to actually could vote on this. And if we could prove there's enough parks in the area, then there's no need to have a rec fee. And I'm not, this is not a residential building. This is a commercial building. And the planning board could just squash this if they wanted to, because it really, there's really no, moving that lot line doesn't demonstrate that it's going to have an impact on the rec fee. So I really think the planning board could take a vote on this now and decide that there doesn't need to be a rec fee. I talked to a couple of municipalities and both of them told me we never charge a rec fee on commercial property. Residential property is one thing. If you read this section, it just doesn't make sense. This is about kids playing on a playground. And if you look around our shop anyway, there's about 5 playgrounds within a mile. You got Circuit and Pleasant, you got Main Street and Marbledale, you got Fisher and Marbledale. There's playgrounds everywhere. It just doesn't make sense.
Hey, Gary, did you hear what Mr. Tavalla said?
I did. Yeah, when the mayor calls, you got to answer him.
Okay, sorry.
No, this is a determination made by the building department based on the interpretation.
But it does give the planning board some leeway to make a decision on their own if they see fit. I mean, if you
of the value. Yeah, I think of the value. I think you're right, Paul. But if you're saying, hey, I don't want to pay a rec fee, then what?
No, I would pay. I'm all on board for paying the rec fee. I mean, up to $10,000. But I mean, now first, I spoke to Bill. I wanted to straighten this out during the week. All of a sudden, he came up with, oh no, it's going to be based on $630,000. I said that's $63,000. I mean, I'm just moving a lot line. And then he came back today. He left me a message saying I couldn't make it out, $300 and something thousand. So, I don't know who's making this rules up, but it almost seems like somebody's out to get me here. And I'm not trying to be respectful, but
well, everyone likes you, but it is up to the planning board. Let me read give me a sec. You guys can go ahead. I'll just try to get
But it sounds okay. So it sounds like we have 2 different values. I'm not sure how we have 2 different values. We have your value, which you said is the new lot is $630,991, and we were told that the value of the lot is $326,860. So I'm not sure where we got.
Yeah, well, he pulled because when I complained about that number, he went back and decided to try and figure out what the land was worth without the building.
Right. The building's not a building. It's just a land, a lot.
So I don't, but like I said, it's not really a new lot. It's really just a light lot line adjustment. And I think I should pay the rec fee based on the amount of the value change of that parcel that was added to it. That would be more reasonable. I mean, you got to agree that paying $30,000 for a rec fee, that's a lot of money.
Let me remind the board that the previous gentleman up on White Plains Road just paid $36,000 in a rec fee for a small piece of property up on White Plains Road. And the gentleman on Marbledale Road who has commercial property also paid a rec fee. I believe it was in the $60,000 or $70,000 range. So just keep that in mind.
All right, sounds like we have 2 options, two remaining issues to finalize. One is finalize cleaning up the site, and the second one is a rec fee.
Well, I think we can work on cleaning up the site with the tenant who's there, because it's more his responsibility than the property owners. So that we can do. But in all fairness to all the previous applicants that have come before this board for lot line adjustment or otherwise, they've all been treated the same with the same set of circumstances.
My issue is that when we spoke about this, I asked you guys, what is the rec fee gonna be based on? And right in the minutes, and I don't know if it was Gary or Leo, what one of you had said, or maybe two of you had mentioned that the rec fees gonna be 10% of the differential increase in property value.
We might have misspoke. Again, I don't know. We have to go back and check, but we might have misspoke. But the building department is the final arbiter when it comes to something like this.
I mean, the planning board, I mean, it gives you guys the authority to make a ruling on this. I mean, do you agree with me that, I mean, I just don't, there's enough parks around that I think that it's covered. And, you know, I don't mind paying fee. We've been in this town for 70 years, so I'm all for anything for the town, but within reason. That's all I'm asking.
Yeah.
Is there a way that we can get a clear understanding as to how the rec fees are applied?
In what sense?
Well, what
Yeah,
he was,
Adrian, it's 7-2, the subdivision approval. That defines the rec fee of when you apply it and how much it's for.
Mhm.
There is definitely ambiguity in that section. Bill has made a determination on it. You guys can say, hey, no, I don't think, you know, the 300,000 is correct on that. I think the difference is, you know, 100,000. Well, he's adding $100,000 to his property by doing this and pay the $10,000. I know Pause and Play was a different situation. That was one big lot where he actually created a new lot. So that means you're bringing more people into the village by that creation of the new lot. So that is a different circumstance. But I leave it up to you guys.
Like I said, with our commercial building, I mean, moving that line, it's not going to change the amount of people in the town, whatever. I mean, it's just their businesses operating there. And
I know it's unfortunate, but it's triggering, you know, this particular clause because you're moving it, and you know.
right. And I
you're moving it to sell the building. It's just
I kind of feel like it's even not a new lot. It's just going to be more of a lot line adjustment. So there's that wording in there that's kind of bothering me too. I mean, I'm taking away from one of my pieces of property, adding to the other one. The impact on the community doesn't seem to be that much. But listen, like I said, I was willing to pay up to that $10,000, but if we're going to start talking $30,000, $40,000, $50,000, then I don't know. I got to figure something else out.
is it normally, what, I guess I wasn't clear, and thank you for the information that you shared, Gary, but is it on the difference between what the new division is going to be, or what's going to be incorporated, or the total property?
It's always in the past been the total property.
Okay.
I think we need a little more information. It's a unique situation. I don't know enough about it to make it kind of.
Same thing with the gentleman up on White Plains Road. He moved the lot line and he paid his rec fee on the full value of the property. Like I said, he just sent us a check for, I believe it was $36,000.
Was that residential or commercial?
Residential.
Residential. There you go.
Oh, but we also had the same issue with Pause and Play, which is a commercial. He created a new lot, and he also paid us the 10% rec fee.
I did copy and paste 7-2 that Gary mentioned, so it's in our chat box. Adrian, if you want to refer to, okay?
Thank you so much,
All right.
Carolyn.
Of course.
Say that again, Carolina. Sorry.
The 7-2 that Gary just mentioned that covers that part, I copied and pasted from our code of ordinance. So if anybody wants to quick reference that. It's right there in our chat box.
Okay.
All righty.
Gary, I think unless I'm wrong, if the applicant is not satisfied with the decision, the only choice he would have would be to appeal it to the zoning board.
That would be correct.
Mr. Tavalil, would you like to think about it?
I mean, I mean, what number are we basing the 10% on now? That's the first question.
The number I have here is the value of your land is $326,860. So
In
that
that
means
case,
the 10% would be $32,686.
Yeah, I mean, I have a brother and sister. I have to talk to them about it. How would I appeal to the zoning board? Is there a phone number or?
But you gotta go through the building department, I guess, right? To appeal to the zoning board, Bill?
to fill out an application appealing the decision of the building inspector.
I mean, there's no other way around this. I mean, do you, the minutes in the, from the previous meeting, then that doesn't hold true?
Well, again, if it's there, again, if one of us misspoke, unfortunately, it was an error on our part, but that's what the law states. That's what the law states.
All right, well, what are you gonna do?
All right, so I guess you're gonna appeal to the zoning board?
I guess so. I don't have much else other choice.
Okay, that's fair.
All right,
All right, thank you very much. Have a good evening.
thank you.
Good luck, Paul.
3133 Main Street.
Good evening, Chairman Leo, members of the board and staff. Bob Stanziel, architect representing 3135 Main Street. Lisa Rabicki's here with us as well this evening, the proposed tenant for the space. We had gone to the zoning board last week and received the variances we had requested. There were some conditions that were applied to that approval, and correct me if I'm wrong or right, Bill and Gary. One was that the tenant, that Lisa would have a monitor at the front of the building to ensure that no one would be parking or dropping off anybody in front of the building. And also that we'd also, as we said originally, rent 3 spaces which are available in the somewhat controversial Lake Street lot. Well, not our spaces, hopefully, as well as the 2 spaces that we have on the property as well. The zoning board did not specify or have a preference as a drop-off area. So they pretty much, I suppose, left it up to your board, Chairman Leo. So.
Right. So yes, I saw the zoning board meeting, and they made some good points, and I think it's valid that we have ample locations where parents can park their vehicles and walk either across the street, around the corner to drop off their children. So I think not to have a designated drop-off or pickup area probably makes sense given the ample options we have as far as parking. We have Lake, we have the train station itself, we have other on-site street parking. So there's several parking lots in that area that hopefully a responsible parent would park there and just walk their child to your door.
We still intend, if I can interrupt, we still intend to create the rear entrance, but really as a rear exit.
Okay.
For the building as a secondary exit only.
Right. Do you have the plan? Do you want to just put it up so that?
Sure, absolutely. If I could share. Yep.
Okay.
All right, you're up here before. What happened to you? Okay. So again, this is the overall site plan showing the interior space. And I know we have to, I know there's some shortages, as you mentioned last time, Mr. Chairman, on the accessible toilet rooms. So we'll deal with that with the building department. So this area that I'm circling now in the rear of the building would be just a exit area. We're still going to reconstruct the stairways to the platform to make them legal exits, conforming with current building code. This would be the rear entrance itself. These are photographs on the bottom of what exists currently. So we'll be addressing that, putting a proper door at the exit over there, closing up this overhead door that doesn't serve any purpose currently, and putting probably a new canopy or canvas awning with some lighting above there, proper exiting lighting that's required by code.
Can you be specific of what you're putting there, what color it's gonna be? Unfortunately, we're gonna have to answer those questions.
Yeah, there is a current, you can see this sort of metal awning that goes over the stairs now to provide protection. We're going to put a new canvas awning over there with some lighting underneath, some down lighting to provide proper lighting for the exit itself. These stairs are going to get rebuilt as per code. There will be a new stair giving access to the platform from the post office, and there'll be a railing around this exit here for the dance studio that'll separate that from any other activity going on the platform of the post office.
On the right-hand side, is that a ramp? Oh, at the the arrow going down right there, yeah.
That is a ramp. Yeah, they use that to wheel up carts, things like that for the post office.
All right.
Yes.
And you're still building the rear corridor in the basement plan and coming upstairs, correct?
Yes, we are. Yeah. Yes. Yes.
Okay.
This is sort of schematically where it's going to be in the building. We have to rebuild these stairs that are in the rear that are not proper and they're not code conformance, and creating a fire rated corridor to the existing stairs that lead to the dance school.
Will those corridors have some sort of a video surveillance system just to make sure that?
Yes, there'll also be, again, it's really strictly at this point, we're just looking at it as an exit corridor, but there will be video surveillance throughout. Yes.
Okay. And who was just curious, who's going to be monitoring that?
The
the
staff,
dance studio?
Lisa's staff will be monitoring it. Yes. Mhm.
All right. Does anyone from the board have any questions on this application?
None here.
None. I think we've addressed a lot of issues.
Okay.
So thank you for your help with this. Thank you.
No worries. So at this point, I make a motion to open the public, to reopen the public hearing. Can I have a
Don't
second?
move.
please? All in favor? Aye.
Aye.
I'm
Just for
assuming everyone else is aye.
clarification, Chair,
Sorry?
it's, I think we're just opening the public hearing now because we weren't able to do it until the zoning, and they got their
You're
special
right.
permit
You're
from the zoning board,
absolutely
which they
right.
just got this month.
Okay, so I make a motion to open the public hearing. Can I have a second, please?
Second.
All in favor? Aye.
Aye.
Okay. Is anyone here this evening to speak on this application?
Yes. Hi,
Can
I'm
you
Jennifer.
identify yourself and your address, please?
Yes, Jennifer DeFabia, 25 Main Street. I am the business owner of the dance gallery at 25 Main Street, and it was brought to my attention that 3135 Main Street will have access to 3 parking spots, as well as a potential drop-off plan. Not only will this add confusion, since there will now be 2 dance studios trying to park in the same lot, but it concerned me for the safety and well-being of my students and patrons of the village. How will 3135 Main Street regulate their clients to, number 1, not park in the dance gallery spots, and number 2, not block my spots or my clients from pulling in and out of my designated spots? I am aware that there was a traffic study done for Main Street and Columbus Avenue, but has there been a new traffic study done for the intersection of Lake and Main Street and Lake Avenue for the traffic flow in the village and pedestrian activity during these peak hours? We all know this is a very tricky intersection. I'm just concerned with adding additional traffic and the ins and the outs of little dancers coming, that this may be an accident waiting to happen. So I'm just asking the board to look into the traffic flow and safety plan during those peak hours and on Saturday mornings, because as business owners of 25 Main Street, we can't be standing downstairs making sure, people aren't parking, non-patrons or not parking in our spots. So I'm just a little bit concerned about the flow and the confusion of the studios and parking so closely together. So if you can just clear some of that up for me.
Sure. As you just heard, we basically indicated that the parking for this facility can be anywhere within the village. So it could be Lake Avenue lot, it could be across the street in the Starbucks lot, it could be at where the bank is, it could be to the left of Village Hall. So it really could be anywhere within I guess a reasonable distance to the school itself. So parents are free to go anywhere, wherever they find a parking space, they could just park there. Where you're located, the Lake Avenue lot, the village, in essence, owns those lots, those parking spaces. So like you or you purchased X number of parking spaces, this tenant will also purchase 3 parking spaces in the lot. My understanding is that they, as long as you have a permit, you can park anywhere within the lot, with the exception, I think, of those 11 parking spaces by the ramp going down into that area. So, conceptually, so this school starts at 4 p.m. My understanding is that the permit parking expires at 4 p.m. So I could park there if I want to go into the city after 4 p.m. anywhere there. The people who live nearby can park there temporarily. So anyone can park in that lot. And unfortunately, it's a public parking lot. And so unfortunately, that it is what it is. So hopefully that answers your parking question. As far as traffic study, this village has done so much as far as, especially in this particular intersection, so many different traffic studies because of the development that's gone, up nearby. The most recent one, a traffic study that was done was for the TLE, which is the old Epstein space, and that will be an early childhood daycare center, basically. So they did an extensive study, parking study. If you want to look into it, you can probably ask for it at the building department, and they can probably provide that to you. The reality is, each project that we add into the village, it's just going to have a minor impact on that light, and it's been the vein of my existence since I've been a resident of this community for over 20 years, almost 20 years, sorry. And I avoid that Main Street light like the plague. I do everything possible to go around. I don't speed and I don't try to beat the light. And I heard you say that the zoning board, but I do witness exactly what you had indicated. It has been studied. I think even the village has recently studied to try to figure out how they can take some time away from the light itself, and I'm not sure what the end result of that was. And by the way, it is the most frustrating intersection to navigate as a vehicular driver or a pedestrian. It's just I jaywalk all the time because I don't know where it's coming from. Will this project add anything, any potential traffic to the space? They're going to have 10 people. 10 kids, I think it is, per class. It's not very large. I'm not sure how large your classes are. So I think the impact will be minimal. But if you take the cumulative of all the different projects, it's unfortunately that Main Street is just a main thoroughfare through, east to west for, I guess, I'm not sure how many miles north or south. So it's a heavily traveled road. And unfortunately, these are the circumstances that we have.
Is the drop-off still on the
Drop
table?
off cannot be in front of the building whatsoever. If we find that the drop off is in front of the building and they get 3 citations, I believe, within a year, they have to come back to us and we'll have to deal with it. Potentially.
Are they allowed to drop off at 25 Main Street and walk up the pedestrian ramp, which was discussed at the zoning board?
Potentially, yeah. If let's say if my child, belongs to that studio, I can come down to the Lake Avenue.
Right, but it's not like a car line. Like they're not.
No. Again,
Not a designated area, no.
Okay.
Yes, basically we're saying, if 10, 15 kids show up at, let's say at 4 o'clock, parents can park anywhere they see a parking space. Realistically, across the street where the Starbucks is, at 4 o'clock, it's fairly empty. Where it's busy is when the trains come in.
Okay, there's not like a circle, because I saw that circle area on the plan.
Initially, we had talked about that, and I think, when everybody put their heads together, I think this is probably the best solution for this particular site. because it is a challenging site. But I think the best solution is to just allow the parents to park anywhere, with the exception of dropping off your child in front of the facility.
Okay.
Because if that traffic gets blocked, it'll become a disaster, and then we're gonna have to revisit it and say, okay, this is a problem.
Okay. All right.
Figure it
Thank you.
out, or we're gonna have to take other measures.
All right. Thank you.
Welcome. All right. Does anyone else wish to speak on this application? All right. Since there's no one else, I make a motion to close the public hearing. Could I have the second, please?
Second.
All in favor?
Aye.
Does anyone from the board have any questions, concerns, issues on this application before we proceed?
I have, my only concern is safety, and if the parent accompanies the child and is legally parked, I really don't have a question.
Okay, and that's the key to the applicant, Lisa. I mean, the key is to make sure that your parents are fully aware that under no circumstances are to drop their child, even for a second, and because you'll be penalized, and unfortunately,
Right.
So you got to make that a part of your contract that they can't park there, otherwise they can't attend your school or something like that. Because unfortunately, you're going to invest money in this facility, and if you have issues, we have to deal with them.
Yes, I put it on my registration form, so they know the minute they register
Right.
that they'll have that.
In the
And my-
beginning, you should also have a monitor outside shushing people away. in
I
the
do,
event
yes.
that,
Yep. Yeah, the zoning board requested that, so we intend to do that certainly. Yeah.
okay, great. Dave, you have a resolution?
Yep. Okay. Planning board resolution, applicant Dream Acres Performing Arts Incorporated. Location of the projects 31-35 Main Street, section 33, block 2, lot 39. Description of the project, applicant is seeking to operate a dance studio at 3135 Main Street. Okay. The following is a resolution decision of the planning board in the village of Tuckahoe, New York. Applicant is seeking to operate a dance studio at 31-35 Main Street, Tuckahoe. The location is a pre-existing building that is adjacent to the Tuckahoe Post Office. The location's fronts Main Street, an extremely busy road, coupled with the post office traffic makes this a very difficult location. The location has been vacant for years, and we understand the importance of the need for a tenant in the space, for this space. We therefore find, based on the work sessions and presentations at the public hearing, that the applicant has met its burden as to 7-1 of the Village of Tuckahoe zoning code, but based on the difficult location, we must apply strict conditions to ensure the safety of the patrons and the safety of the village roadways. The application is approved with the following conditions. Number 1, there shall be absolutely no drop-off or pickup of students either on Main Street or Columbus Avenue. Number 2, chaperones drivers must use legal parking spaces and walk their children to the studio. Condition 3, at the outset and for at least 3 months shall be a monitor outside the studio to ensure there is no drop-off or pickup in front of the studio during drop-off or pickup times. Number 4, the studio hours shall be Monday through Friday, 4 p.m. to 10 p.m. The 4 p.m. start will coincide with the Lake Avenue lot becoming available to the public as the permit spaces end at 4 p.m. Saturday hours shall be 9 a.m. to 5 p.m. Number 5, if there are 3 complaints in any 12-month period of students being dropped off and picked up in front of the studio on Main Street, then the building inspector shall refer to the applicant back to this board to determine if this site plan shall be revoked. And number 6, applicant is responsible to notify the chaperone drivers of the above restrictions and must ensure compliance with the same. And lastly, number 7, approval as per drawings dated 6/28/2022, revised on 7/19/2022. Okay, every representation of the application made in its application and presentation will be a condition of this approval. Any deviation from the representation made shall be cause for the revocation of said approval.
Can I have a second, please?
Second.
Nancy, please take roll.
Commissioner Nirenberg,
4,
Commissioner Barra,
4,
Commissioner Carpenter,
I think I'm gonna abstain from this one because I haven't really heard about it. I mean, this is the first time I'm really like listening into this.
Okay.
Commissioner Wolfson,
4.
and Chairman Leo.
In favor. Welcome to Tuckahoe. I wish you much success and good luck. But please, again, it's important that your parents realize that they're not to park or drop off their children on 25 on Main Street. Okay.
I got it. Thank you so much.
Say
I'm
hello to
so
your new. Say hello to your new neighbor. Hope you guys.
Yes.
Chairman Leo, members of the board, thank you so much, and staff, as always, Bill and Gary, thank you. Appreciate
Okay,
it.
guys, thank you.
Thank
all
you.
the best. Best of luck to
Thank
you.
you.
Good luck.
Thank you so much.
You got it. All right. Good luck. Since we have no other business, I make a motion to close the public hearing. Can I have a second, please?
second,
All in favor? Aye.
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 Good night, Tuckahoe.
Good night.
Good night, everyone.